across the Parliament that these provisions are useful.
The Honourable Ruth Dyson.
Thank you very much, Mr Chairman. I understand that when we're discussing issues in the Public Works Act that the problem of compensation and the rate is important, and I appreciate the contribution that have been made by a number of members tonight, but that's not the particular clause I want to address in my contribution, or my first contribution anyway. I would just say to the Minister, though, that I think the Public Works Act was 1981, so he would have graduated to secondary school by the time this was last debated in Parliament rather than at primary school. I want to address the provisions that are in Clause 169, and it's one of the few provisions in the whole of this Resource Legislation Amendment Bill which was not amended at all by the Select Committee. So it's quite unusual. 169 was just completely intact. So when I read through the submissions on this clause, I expected that all submitters would have been in support of it. I thought, well, if it hasn't been touched, then the submitters must have all thought it was a jolly fine thing, but actually they didn't. One submission that I was particularly interested in was from the Resource Management Law Association. So that's a group that is specifically interested in the law that we are debating right now. They supported the intention of the clause. Oh, perhaps go back a step, Mr Chairman. The Clause 169 amends Section 24 of the Public Works Act. It puts in a new subsection, and that subsection allows for the Environment Court to accept evidence that's been presented at a previous hearing on a related inquiry or an appeal by the court. So you don't have to go through repetition of the same issue, even though it's being heard by different jurisdictions. So that's the intent of this. The Resource Management Law Association supported that intent. They said this is a good idea, but, and this is the important bit, and I want the Minister to explain in a way that I can explain to my constituents why he didn't agree with their remedy to fix what they saw as a fundamental flaw in this clause, and that was that it doesn't achieve the purpose that it's intended to achieve. You can't get much more fundamental than that. That's the intention, reducing the duplication between the various jurisdictions so the hearings can be just heard again on the same basis rather than a new regime having to be invented for the next hearing. But they said that alignment does not occur through this Clause 169. If people that are involved in resource management law ask us as members of Parliament, this is what the association said, this is what the Law Association said, they're the experts in this area, why didn't the committee change it? Why didn't the Committee of the Whole House change it? Why did the Minister block a suggested fix to a problem presented by a group of people who agreed with his solution, but just said this clause won't achieve it? So that's the question that I'm really keen on having answered by the Minister. Not only did the Resource Management Law Association say that this isn't going to fix the problem, they actually suggested ways of doing it. So it was really icing on the cake. All the Minister had to do, and I understand the Minister was very heavily involved in the detail of this work, even though it was being heard by a Select Committee, all the Minister had to do was pick up their suggestions and move it across. So, Mr Chairman, I'm keen on hearing directly from the Minister why that identification of a fundamental problem wasn't accepted, and if it was accepted, why the solution wasn't acted on. I want to ask the Minister one more question before I finish my contribution on this clause, and that is, in what other situations does he consider that this parallel process would be appropriate? What other areas is there duplication where this fix might be applied to? I agree with reducing bureaucracy. I agree with reducing duplication. I agree because it means that more members of the public are likely to have access to situations where they can have their voices heard. But if reducing bureaucracy and lowering access to justice means that more members of our community are denied that opportunity to have their voice heard, then I oppose it with every strength in my body. Too many people are being locked out of having their voices heard. Too many people hear about decisions after they've been made. Too many people are restricted. That's exactly what this provision does. Too many people are restricted, and I want to see what other processes would the Minister have in mind where this could be applied.
Jamie Lee Ross.
The question being
I'm going to hear McAfee Kerry.
I want to make a contribution to Part 3, particularly clauses 1, 7, 2.